Mr. Chief Justice, and may it please the Court.
Do you mind starting where we left off?
I do not.
What's your position on those questions? Do you think the existence of the reservation clause in the original agreement makes a difference if there were no reservation? And the second question is, was there anything that prevented your client from bringing a petition earlier to establish?
There was nothing that prevented him, Chief Justice Kilbride, clearly.
You know, Justice Freeman reminded me, I prevented you from stating your name for the record.
Philip Nathanson for Dr. Peterson, the appellee.
Thank you.
Either side under the statute could have brought a petition. But I do think that your question is important on what is and what is not a modification. You have an original 1999 judgment that says the issue of college expenses is reserved. That's, one could put it, that that's an award of $0 to either side for college expenses. When years later, in 2007, there's a petition filed and there is an award pursuant to that petition.
Counsel, isn't that the father didn't know about it? He would have known about this. Sons were going to college.
I think in a general sense, Justice Burke, he knew his son was going to college. There was conflicting testimony about letter writing and things of that nature as to what the details of Gregory going to Cornell were. But other than a general Gregory's going to college, there was no specific disclosure or petition saying here's the tuition, here's the room and board, here's the books, here are all the details. And I'm assuming, and Mrs. Peterson testified, she was assuming Dr. Peterson would pay for most of this. There was no such disclosure. Of course, in a general sense, he knew about that. Sadly, his relationship wasn't great at that point with his son, but I don't think that's really dispositive. So we don't dispute that, generally speaking, he knew Gregory was going to college.
Mr. Nathanson, do you think the intention of the judge and the parties in the original adjudication indicating that college expenses was reserved was taken to mean $0 for either side?
$0 at that point, Justice Thomas. I'm not saying it meant $0 in futuro forever. I think at that point there was a decision made that on the college expenses there would not be either a dollar amount attributed, because nobody was in college at that point, or a percentage allocation, and you could have that without dollar amounts. I think it was a decision that we're going to leave it where it is, that issue where it is at the moment for subsequent consideration. But as we say in our brief, when there is then an award made, and I admit I've never cited Black's Law Dictionary to this court before, but it defines modification as a change to something. And I think the focus, yes, we have to focus on the 1999 judgment, but the fact is when that petition is filed in 2007 and an award is made, that is a change to something. So you have an issue that's mentioned but not disposed of entirely, and then you have an award both in terms of dollars and percentage allocation that is a change, an alteration, however one wants to look at it. And
but what is it a change to? If they decided to reserve, talking about the issue, nothing was decided. So what's it changing?